Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drower, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Mallory v. Norfolk Southern Railway Company, which was argued before the court on November 8th. It's my honor to introduce Professor Christopher Green as our guest today, who is a professor of law and the Jamie L. Whitten Chair in Law and Government at the University of Mississippi School of Law, where he has taught since 2006. He's written extensively on constitutional theory and the 14th Amendment, and we're happy to have him here today to talk about the case. So I think, Professor Green, we can start off if you're willing to talk about kind of why this case matters, why our listeners should continue listening in this episode.
Well, this is a case that will bring back memories, perhaps fond memories, perhaps. I hope not. I hope it won't trigger too much PTSD from your civil procedure class back in law school. But it has to do with Pennoyer versus Neff and all of the old regime and how much of it survived the transition to international shoe. So I vividly remember a very bad joke saying that before 1977, when Schaefer versus Heitner came down, everybody was waiting for Schaefer to, or waiting for some case to decide whether quasi-in rem jurisdiction was still a thing after international shoe. And of course, then there was, I think, a list of many articles talking about waiting for the other shoe to drop. So there have been many shoes that have dropped, kind of waiting to see the extent to which international shoe replaced the old regime. Lots of talk in the oral argument about Burnham versus Superior Court from 1990, about tag process that survives international shoe. So international shoe says that traditional notions of fair play and substantial justice are the important consideration and then here's the question, really, for the Mallory case, is it just the question for unconsenting defendants, or is this a general regime for all assertions of personal jurisdiction by a state? So it's fascinating because it really gets down to just the very, very bedrock of what the 14th Amendment is, what due process is, what personal jurisdiction is, and the extent to which these old cases like Pennoyer are still kind of the general regime. And particularly, it's an old case from 1917 called Pennsylvania Fire, which upholds a particular kind of statute, which I will explain in a second. But that, in terms of motivation, can't get more motivating, I think, for a FedSoc crowd than getting down to bedrock.
Well, there we go. Thank you. And before we get into takeaways from the oral argument or the things you just mentioned, do you want to give a quick summary of the kind of background of the case, how we got here, before we get into the kind of legal details of the argument?
Sure. So the basic, so in personal jurisdiction, you need to have, under international shoe, you need to have minimum contacts necessary to satisfy fair play and substantial justice. Of course, it has always been a right that can be waived. So you can explicitly consent. So if you get sued in some court and you show up and you say, oh, this is fine, we can litigate it here, I consent to it, you can just give up your personal jurisdiction rights. There's no problem with a court adjudicating in that kind of setup. Well, Pennsylvania has a statute, and it says if you want to do business in our state, you have to consent to personal jurisdiction of the courts of this state. So you have this. So Norfolk Southern Railroad does lots and lots and lots of business all over the country. They are a Virginia corporation, chiefly. That's their principal place of business. This is a Virginia plaintiff suing about stuff that happened in Virginia. So it is a Virginia cubed case. Virginia subject matter, Virginia plaintiff, Virginia defendant. But he's got a plaintiff's attorney in Philadelphia, which, not that far from where he is in Virginia. Norfolk Southern does plenty of business in Pennsylvania. And they've got the statute that the Supreme Court had said was okay in 1917, a generation before international shoe. So this Pennsylvania law firm says, hey, we can just file it in Pennsylvania and do it here. The Superior Court in Pennsylvania says, no, this doesn't seem like fair play and substantial justice to us. Pennsylvania Supreme Court agrees. So the Pennsylvania courts, or Pennsylvania acting through its courts, is not attempting to take advantage of this statute and say, hey, we've got consent to adjudicate it. But then this comes up to the U.S. Supreme Court under 1257. This is the kind of case, by the way, that Justice Stevens thought they should never take. They thought, well, if a state court says that something violates federal law, it's not really any business of ours. We can wait for the state authorities to deal with it. But it comes up, and so this is a follow-on to so there's a concurring opinion in the Ford Motor case from a couple years ago by Justice Gorsuch, joined by Justice Thomas. And he specifically says, it seems like we should take a case sometime soon to decide whether these old cases like Pennsylvania Fire from 1917 are still good law. Okay, so pretty clear who wants to have this reviewed. Steve Sachs at Harvard, he's I would say the kind of leading originalist scholar on civil procedure issues anyway, on this kind of thing. He thinks they should reverse or vacate at least, and then send it back to the Pennsylvania courts on a dormant commerce clause issue. But you've got Justice Gorsuch wanting them to consider cases like this. You've got people like Steve wanting them to consider cases like that. So that's how it gets to the court. It's not, I mean, you always wonder in terms of predicting what's going to happen. Why did they take the case? Is this a grant cert to reverse or a grant cert to resolve a circuit split? Is this a grant cert to resolve an issue that's been raised earlier in a concurrence or dissent from denial of cert, that kind of thing? It's definitely a grant cert because Justice Gorsuch thinks Mallory should win. He thinks Pennsylvania is allowed to do this. The 1917 case is well reasoned. It seems pretty clear from his comments at oral argument that Mallory is starting out with at least that one vote. But it's unclear how many. I think he definitely has. Mallory definitely has Sotomayor's vote on grounds related to her kind of dissent / separate opinion in the Daimler case from 2017. It's not clear that Mallory's got more than two, though, to me. So, but that's the basic issue is, can Pennsylvania say, in order to do business here, you've got to consent to personal jurisdiction? They are the only state at this point that has a statute that explicit. There's a bunch of controversy in the oral argument about exactly how many there were at different times, how many there were in 1868. But the fact that it is the only state doing this today, I think, is a pretty significant fact. Certainly Chief Justice Roberts, I think, honed in on that. And that may be, I think, one of the key facts when the decision comes out.
So in terms of the implication of the due process clause, do you want to talk a little bit about how all of this kind of comes to bear? Like how you referenced 1868, of course, the 14th Amendment, basically how the due process clause factors into all of this before we get into the oral argument.
Sure. So one big question, and this showed up last spring in a number of the cases like Dobbs and Bruin. So those are substantive due process cases. Most people think that they could be shifted over to privileges or immunities clause, footnote 22 in Dobbs, that kind of issue. But one thing that was interesting is the fact that there are two different kinds of facts about the distribution of states that you can look at in gun cases, abortion cases, in civil procedure cases. You can look at the number of states that had a certain kind of statute at the time of the adoption of the 14th Amendment in 1868, or you can look at the number of states today. And in Bruin, for instance, they said, "Hey, look, there's a 44-6 or 43-6 if you don't count Vermont, split in favor of the right to carry today." This is the kind of thing that we're doing is imposing a consensus among most of the states. Justice Kavanaugh's separate opinion in Bruin, for instance, highlighted this kind of fact. The fact the court was also very concerned about the exact distribution of states in 1868 at the time of the adoption. At one point, they said in Dobbs, that's the most important fact historically. Well, in the land of traditional notions of fair play and substantial justice, this regime that you've got under international shoe, you have exactly the same split, the kind of different versions of the fact. You can count up statutes in 1868 and you can count up statutes today. One thing that's interesting, at the oral argument in Mallory, a lot of the justices focused attention on Justice Scalia's separate opinion in Burnham from 1990. Justice Brennan was not getting a whole lot of love, but there's a little ditty at the end of Justice Scalia's opinion. Let me pull up the exact language here, if I can. Okay, so at the end of Justice Scalia's opinion for the so it's not an opinion for the court. It's a separate opinion. He has 4 votes. Brennan has 4 votes, and then Justice Stevens says he's not gonna decide. But one of the things he says, nothing we say today prevents. So this is tag process that they're talking about in 1990. So the fact that somebody has been in the state and somebody comes in and says, "Hey, tag, you're being sued. I'm going to sue you here in this state that you're in. Is that enough?" And the court, everybody on the court says that's okay, but they split on the rationale. And Justice Scalia says the reason that this is okay is tradition. Justice Brennan says the reason this is okay is because it's actually fair. But it certainly seems from the argument in Mallory that this will give them the opportunity to say, as a court, that Scalia was right. It's about tradition. But here's what Scalia says at the end. He says, nothing we say today prevents individual states from limiting or entirely abandoning the in-state service basis of jurisdiction. And nothing prevents an overwhelming majority of them from doing so, with the consequence that the traditional notions of fairness that this court applies may change. Okay, so if what Scalia says in Burnham also applies to a state extracting consent to personal jurisdiction, it seems like Norfolk Southern is going to win, because an overwhelming majority of the states, all of them except Pennsylvania, do not do it this way. The question, I think the key interpretive question in terms of looking back at Burnham is, does this really apply to consent as well as to non-consenting assertions of personal jurisdiction? And Mallory certainly argues, and has some basis for saying it, that this is only for non-consent. There are a few passages earlier in Scalia's opinion where he sort of says this, international sue and traditional notions, that subsumes quote consent, unquote. So the kind of slightly fictional version of consent that happened in the 19-teens and 1920s under some cases, but does it actually trump consent, where you've explicitly said, I hereby agree to be sued and I'm giving up my personal jurisdiction rights in exchange for the right to do business in your state. I think that's one big question that's looming, is just what exactly does this stuff from Burnham apply to? So I think the future civil procedure students of the world will look forward to this being a clear case, just setting out exactly what the rules are for that.
Sure. And are there any, I know we started talking about the oral argument. So are there any other kind of key moments during the oral argument or takeaways that you think would be worth talking about?
Sure. So I think that one of the big takeaways, the big things they're struggling with is, the one question, did the railroad consent? And then there's another question, is this consent something that Pennsylvania was okay when they extracted? So that would be a dormant commerce clause issue, where some people have said the dormant commerce clause stuff should be shifted to the comity clause of Article 4, Section 2, Clause 1. So there's a bunch of, there are a lot of time taken up at oral argument saying, should we think of this in terms of an unconstitutional condition on a right that you have under the dormant commerce clause, or I don't think anybody actually explicitly mentioned Article 4, but that certainly would be on the table as a way to think about it. Well, one issue with Article 4, of course, is that corporations traditionally don't have Article 4 rights because they're not citizens; they're just persons. But there's a bunch of questions just about how to think about unconstitutional conditions. I think everybody agrees that there were a couple of laugh lines about how confusing unconstitutional conditions doctrine is. So it's possible that this will also be a big case on unconstitutional conditions, which really would be a kind of a theoretical, a good thing to have them just really dig into that issue. In terms of the argument, kind of counting to 5, it seems like Norfolk Southern can count to 5 much more easily than Mallory can. So Justice Kagan was very clear in a number of her questions that she thinks she's asking the questions from the side of saying, look, they've got a right to do business. You can't just demand that they give up the right in exchange for having personal, can't give up the right not to have personal jurisdiction. The kind of right you have under the Daimler case, you can't just make them give that up as a condition of doing business. Justice Jackson, I think, was of a similar mind. Justice Kavanaugh had a kind of pragmatic, asked some pragmatic questions that suggest that this would be an end run around Daimler. I don't know if they ever actually used the word end run. So the standard rhetorical move, if somebody accuses you of making an end run around some earlier doctrine, is that the end run is a legal play. You're allowed to not go into the line and go further out in football. But the argument that the sense that, hey, this doesn't make sense given what they just said in Daimler, that seems to be pretty widely felt down the line. Justice Sotomayor didn't like Daimler. So she says, look, you're doing all this business in Pennsylvania. Just, just deal with the lawsuit in Pennsylvania. If the plaintiff wants to be there, it's no skin off your back. You're huge. You can do that. So I think it seems like Mallory has got Gorsuch and Justice Sotomayor, but Kagan and Jackson. Roberts made this point, picking up on some of Justice Scalia's comments about traditions being able to change. Kavanaugh had the pragmatic thing. So and Justice Thomas he joined Justice Gorsuch's opinion in the Ford case, but it didn't seem like he joined an opinion prior to this Gamble case on dual sovereignty exceptions to double jeopardy. And a lot of people thought, he and Ginsburg are both going to want to overrule that old doctrine. And then he said, no, actually, after I looked at the details, that earlier concurrence meant what it meant. It meant what it said. It meant that this is an issue we should look at. And actually, having looked at it, we shouldn't overrule these old precedents. So Justice Thomas could do a similar thing in this case. Justice Barrett asked some. It's interesting learning how to decipher what these new justices think from what they say at oral argument. She obviously had looked very carefully at the case. She said, well, suppose I disagree, asking Mallory, Mallory's counsel, suppose I disagree with your reading of some of these old statutes. What would we do then? She didn't have a follow-up, though. So it was unclear whether she was satisfied or not with that answer. And I think if you read her law review articles, it's clear she's just very careful about what she's saying, what she's not saying. She doesn't like to tip her hand during oral argument, and she didn't. But at least she did say, she was skeptical about the reading of some of those old statutes. So I would put her it seems from those into the lean Norfolk. So this could be 7-2 for the railroad. Could be somewhere else, but it seems like the railroad is likely to win this. This is not going to be the wave of the future, and kind of an increasingly popular way for states to get around Daimler. It seems like the Daimler rule, which was it was 8-1 on that rule in 2017. That's not going anywhere, and it doesn't seem like this is a way to get around it. So I think Steve Stacks and friends may well be disappointed by the result here.
All right. So my next question was going to be about predicting the results, but we covered that quite seamlessly. So I guess as we kind of get towards the end portion of the episode, is there anything else that you think is worth covering with this case? Anything else you'd kind of like to leave the audience with after that quite good analysis of the argument?
Nothing particular to add. I think it is one to look forward to, and it's there's no question. You can read next year's CivPro casebook supplements this year if you take a look at this case. So it's catnip for people who are interested in just the really fundamental issues underlying the civil procedure system that we have, and I look forward eagerly to devouring into it. And I, of course, hope there's lots of separate opinions and concurrences to make it more interesting.
All right. Well, Professor Green, thank you very much for coming on SCOTUScast today and talking about this case. We appreciate having you.
Thank you.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.